Hello, everyone, and welcome to today's webinar from the Wagner Law Group. We're going to talk about the impact of our current economic challenges and environment on retirement plans, and specifically on single employer defined benefit pension plans. In the future, we'll be having another webinar on defined contribution plans. My name is Steve Wilkes. I'm a partner in our San Francisco office, and I lead our ERISA fiduciary group, and I'm joined by my senior colleague and good friend John Schultze, who is the partner in charge of our employee retirement qualified plan practice. Hey John, how are you today?
I'm good, Steve. It's a nice day.
Good. Okay, so we have a lot to cover. We're going to be covering a lot of operational and administrative matters as a result of recent law changes that impact real-life, day-to-day issues in our plans. And John is going to take the lead on that. I'm going to turn this over to him in a moment. And at the end, I'm going to finish up with some of the overarching fiduciary concerns that we face during these times with regard to DB plans that are somewhat principle-based. So I'm going to try to call out some of the important issues and things that we've seen in the past during prior recessions or volatile economic cycles that have come to our attention that we'll point out for you going forward. So, John, it's all yours.
Okay. The current volatility in the economy due to the coronavirus pandemic has created various issues for retirement plans that need to be addressed in an expedited and efficient manner. The impacts on single employer defined benefit pension plans can be categorized into three broad areas: day-to-day plan operations, plan administration, and fiduciary matters. Each of these categories has a range of considerations which we're going to walk through in this webinar. While many of these considerations are also important for multi-employer plans and sponsors of plans in bankruptcy or liquidation, these topics really are beyond the scope of this webinar. We want to make a distinction between a suspension of employment and a permanent severance from employment. A furlough, leave of absence, or layoff of a temporary nature generally would not be considered a severance from employment. A permanent layoff or reduction in force generally would be considered a severance from employment. And the distinction largely depends on the intent of the employer. Will these employees be coming back? For a suspension of employment, there are impacts on eligibility to participate and accrued benefits and vesting. In elapsed time plans, an employee is credited with periods of service, which generally means the employee must be employed at the beginning and end of a specified period, not more than 12 months, or for some other specified period of time. In hours of service plans, an employee generally must be credited with a specified number of hours of service during a measurement period. And hours of service are credited for actual hours for which the employee is paid or entitled to payment, or based on Department of Labor hours equivalencies. The contributions that the employer is obligated to make to fund the plan are generally determined on an annual basis. For benefits based on compensation and/or service, unpaid leave means participants might not accrue benefits or the same benefits they would if they were working full-time for a full year, which could affect the following year's funding calculations. Now note, we're going to talk about some CARES Act changes below that may impact this. Compensation typically is a defined term in a plan, and the definition may or may not include certain payments to employees who are on leave. We should note also that most plans do not give participants access to their benefits until their employment terminates. And even then, it might not be payable until the participant reaches normal retirement date. There are instances lately where essential workers are being called back on an as-needed basis, such as doctors, emergency personnel, etc. Some defined benefit plans have a suspension of benefits provision that basically says if you come back to work for us, you are not going to continue to receive your pension. So employers might want to consider eliminating or temporarily suspending that suspension of benefits rule if it's appropriate and if it's applicable. Under a permanent termination of employment, which are layoffs and reductions in force, payment requests from participants still have to be processed for those participants who are eligible to receive distributions. And if there's a sufficient number of people, participants who are laid off or subject to a reduction in force, a partial plan termination may occur. And that could be one or a series of layoffs that affects 20% or more of the workforce, in which case terminated participants have to be made fully vested to the extent the plan is sufficiently funded under ERISA's ordering of payment priorities. Now, it's uncommon, but some defined benefit plans may permit in-service withdrawals to participants as early as age 59.5, or permit participants to take loans against their accrued benefits, and the limits on the loans would be the lesser of 50% of their vested accrued benefit and $50,000. But it's important for participants to understand that the benefits are intended as post-retirement income, and that income will be reduced if they take out a loan or take an early distribution to pay for their short-term needs, which could potentially strain their finances in retirement. Moreover, if they take a distribution, they may owe income taxes on the amount they receive for that year of distribution. In terms of loans, the one aspect of loans is that there's a cost to taking out a loan. There's fees on the issuance. Repayments are made from a participant's after-tax amounts. There are potential taxes and penalties if the participant misses a repayment or defaults on the loan. And if the loan is not repaid, again, we've taken long-term retirement income to pay short-term needs, which could strain finances in retirement. The CARES Act expanded the availability of in-service distributions and modified the loan rules that apply to qualified retirement plans generally, not just defined contribution plans like 401k plans. It's not entirely clear whether the CARES Act options were intended to apply to defined benefit plans. And because of the limited availability for most defined benefit plans of in-service distributions and loans, these options might be considered when further guidance is available. But the upshot of the CARES Act provisions is that amounts that are taken from a plan receive favorable tax treatment. And that could be as in-service payments or lump sum distributions if a plan so permits to a terminated employee. And loans also are subject to more favorable treatment. If an employer wants, it can amend its plan document or loan policy to add flexibility to the loan program, such as allowing additional loans, or to add the in-service distributions, subject to various restrictions that generally apply. In terms of the requirements for benefit accruals, the length of employment suspensions can affect the benefit accruals and or vesting service. For example, many Northeast and West Coast states instituted stay-at-home orders by mid to late March, barely 3 months into the calendar year, and it's uncertain when employees will be able to return to work. So it's premature at this point to speculate what the actual effect will be, but it's entirely possible that a lot of participants will not accrue benefits for this year as a result. So what are some of the options for a sponsor that foresees longer-term financial difficulties? Well, one option is to freeze its pension plan. And there's 3 flavors of freezes. The first is a soft freeze, which means new employees do not become participants. Current participants can either have their benefit accruals frozen and increase as their compensation increases in the future, or they can be continued at the same levels. The main point is new employees do not become participants. A partial freeze applies if benefit accruals are continued for certain groups of current participants, but discontinued for others. One item with that is to be mindful of discrimination issues. You want to be sure that the groups whose benefits continue is a non-discriminatory group within the entire plan participants. The third option is a hard freeze, in which all benefit accruals for all participants are discontinued, and benefits are determined based on compensation as of the freeze date. If a sponsor intends to freeze its plan or otherwise reduce benefits, a notice must be provided to participants and other individuals before the freeze takes effect. The general rule is that the notice must be distributed at least 45 days before the effective date. But if the plan has fewer than 100 participants with accrued benefits, a 15-day rule applies. And the 15-day rule also applies in the case of a business acquisition or disposition. And note, benefits that have already accrued cannot be taken away, and that freezing a pension plan really will only provide short-term relief, but will not provide much short-term relief, but may provide longer-term relief by containing the future pension costs. Also note that a collectively bargained plan might be subject to collective bargaining agreement that will restrain the employer from making certain changes to the plan. Alternatively, a company could choose to terminate its pension plan. In a standard termination, benefits must be made 100% vested, and the sponsor must fully fund those benefits through additional contributions. If fully funding the plan is an issue and there's a majority owner, the majority owner of that company, of the sponsor, may elect to forego all or a portion of his or her benefit, which means the owner is giving up some benefits in order to provide the benefits to its employees. Company can seek assistance from the PBGC to limit the benefits under a plan to a guaranteed amount if funding is an issue, or seek a hardship termination, which we'll touch on a little later in this webinar. And again, collectively bargained plans may have restraints on what an employer can do to try to control the costs. If a plan is to be terminated, participants must be provided various notices regarding the termination. For a PBGC covered plan, there's a notice of intent to terminate, notice of insurers, notice of plan benefits, notice of annuity contract. Notices also must be provided to the PBGC. A standard termination and post-distribution certification are requirements of a standard termination. And if the sponsor wants to file an application for a determination letter with the IRS, there are additional notices that participants must receive as part of that process. And this process can take 1 to 2 years once you've satisfied all the notice and timing requirements to terminate the pension plan, and including bidding and purchasing an annuity contract to provide the benefits. Whatever options an employer chooses to make during a plan year, it will be required to adopt a plan amendment before the end of the year. Except if they are suspending benefits or making other changes with a prospective effect that have their own time restrictions. In some cases, the timing to adopt a required amendment can be extended. For example, the deadline to adopt amendments for the CARES Act changes will be the last day of the first plan year beginning on or after January 1, 2022, which gives us over 2 years to adopt that amendment. Let's move on to the plan administration issues. The Treasury Department, IRS, and Labor Department can extend deadlines for required administrative filings, including Form 5500, and the 5500 deadline has been extended presently for plans with deadlines falling on or after April 1, 2020 and July 15, 2020. which means calendar year plans do not have an automatic extension to file their 5500s, and the current July 31 deadline will apply for the 2019 5500 unless that deadline is extended by the plan sponsor or its administrator. The defined benefit plan using a pre-approved document had been subject to an April 30th, 2020 deadline to restate the document into a new version. That deadline has been extended 3 months to July 31, 2020. In terms of PBGC filings, if the plan is subject to PBGC's insurance program, premium payments must continue and PBGC Form 1 filings must be made. The deadline for the premium filings and payments and other PBG filings due from April 1st, 2020 through July 14th, 2020 have been extended to July 15th, 2020. But that's the only extension at this point the PBGC has provided. Other reportable events may be subject to reporting on PBGC Form 10, Form 10 Advance, or Form 200, and this includes active participant reductions, failures to make required funding payments, application for minimum funding waiver, inability to pay benefits when due, and total underpayments with interest that exceed $1 million. These deadlines generally were not extended by the PBGC. Another PBGC filing may apply to a reportable 4062E event. And a 4262E event occurs if a company permanently ceases operations at a facility that results in a workforce reduction of more than a 15% reduction in the total number of employees eligible to participate in any defined benefit or defined contribution plan maintained by members of the same control group. Companies may be required to notify the PBGC, but there are several exceptions, such as a plan with fewer than 100 participants does not need to file, and a plan that's 90% or better funded does not have to file a 4062E notice. If 4062E reportable event occurs that requires a notice, the company can elect to make additional annual contributions for 7 years to fund the benefit liability that arises from that reduction in headcount. Essentially, you have to fund the benefits if there's that large reduction in participants. The company also can request a funding waiver from the Internal Revenue Service. Some plans are not subject to PBGC coverage. A professional plan, which is doctors, lawyers, etc., with fewer than 25 participants, substantial owner plans, and certain church plans are not subject to PBGC coverage and do not need to pay premiums or file any kind of reportable event notices. But note again, there are certain notices to participants, beneficiaries, and alternate payees that are required if future benefit accruals will be reduced by a plan amendment, if the employer requests a waiver of the minimum funding requirements, or if the employer fails to make minimum required contributions. Also, if the plan is terminating, notice is required, and if the plan becomes subject to benefit restrictions due to its funding status. So let's talk about funding status. Current investment changes, gains and losses, primarily losses these days, are not likely to have an immediate impact on a plan's funding requirements because the contribution requirements are calculated once each year on the actuarial valuation date, which is usually the first day of the plan year, typically January 1 for calendar year plans. Therefore, daily or monthly volatility does not immediately impact most pension plans. The important date to assess the impact on the assets is on the valuation date. Funding rules for valuations allow actuarial asset values to be smoothed over a 24-month period, which dampens the volatility of a funding shortfall in the minimum required contribution. If interest rates remain lower, they may cause pension liabilities and expenses to remain higher for a longer period of time. Congress can pass additional funding relief that could mitigate cash pains over the next few years, but for the moment, they made one change in the CARES Act that does provide funding relief for single employer defined benefit plans. The due date for the minimum required contributions otherwise due during 2020 may be delayed until January 1, 2021, at which time those contributions plus interest will be due. And interest accrues from the original payment due date through the actual payment date using the effective rate of interest for the plan year, which includes the payment date. And again, companies that are obligated to make contributions under a collective bargaining agreement or by the terms of an agreement with the Pension Benefit Guaranty Corporation may be unable to delay those contributions. Also under the CARES Act, plan sponsors may choose to use the plan's funded status for the last plan year ending before January 1, 2020 for purposes of determining the funding-based benefit restrictions for plan years that include calendar year 2020. For example, if a plan's funded percentage falls below 80%, certain restrictions apply, and if it falls below 60%, further restrictions apply to future benefit accruals and certain optional forms of distribution. So this option to allow sponsors to look back before the stock market dropped can help the plan maintain a more consistent posture with respect to its participants in terms of allowing benefits to continue to accrue and allow participants to take their distributions. So how do you deal with the financial hardship? You can request a funding waiver from the Internal Revenue Service, which permits the company to skip the minimum funding contribution for a year and make repayments over the following 5 years. And the IRS will grant a waiver for up to 3 of any 15 consecutive plan years. So it's not so much a waiver, so much as an approved extended payment plan if you're unable to make a current year contribution. PBGC and IRS may proactively contact a company for more information if funding contributions are missed. And they might see that from a Form 5500, where you have to report the minimum funding contribution was made, or from other filings. And if a payment plan cannot be arranged to make up the missed contributions, the PBGC may, depending on the facts and circumstances, initiate an involuntary termination of the plan to protect the plan and its participants. A company facing more serious financial hardship can request that the PBGC approve a distress termination of a pension plan if the plan is covered by the PBGC's insurance program. The PBGC will review historical and projected financial information and determine whether the company can prove it's financially unable to support the plan. To do this, one of 4 tests under ERISA have to be satisfied, which are a petition for liquidation and bankruptcy has been filed, a petition for reorganization in bankruptcy has been filed, and the court determines that the reorganization is not possible if the plan stays intact, the employer is unable to continue in business, or the cost of providing the pension plan coverage is unreasonably burdensome. Note that all members of the same controlled group as the employer are liable for funding the plan, and each would have to satisfy one of these distress tests in a distress termination. Also, if the PBGC takes over the plan, the sponsor will have to negotiate with the PBGC to settle the liability the PBGC assumes when it takes over the plan. Companies facing bankruptcy or liquidation or that participate in multi-employer plans have additional challenges. A lot of what we've just talked about apply, but there are others that are beyond the scope of this outline. So from a plan administration standpoint, administrators should ask its investment advisors to review the assets, taking into account the short and long-term risks. Review the plan's investment policy statement to make sure it's still reasonable for the long term with an eye toward what's currently happening in the economy. Review the valuations and the effect of the economic changes on the performance. Determine the plan's liquidity needs. If it holds a lot of investments without market liquidity, if the investor redemption options are narrow, then a plan sponsor might want to review whether or not those investments are still appropriate. And also confirm there are no advisor conflicts. Do the advisors handle proprietary products? And are there any affiliated investment advisors? And then any kind of advisor disclosures or information should be carefully reviewed to make sure that it continues to work for the plan's benefit. That's primarily the operational and administrative issues that I'm going to cover. And at this point, Steve can step in and talk about some of the fiduciary matters.
Thank you, John. Let me make a couple of general comments about the fiduciary matters that one faces during these volatile times. And my first comment is that there's really no change in the standards or the law, the regulations, the fiduciary rules apply. There are no specific, provisions or special conditions to satisfy, when a company is in bankruptcy or when you're going through very rough times, rough cyclical times. The fiduciary, if you're a plan fiduciary, you have the same duties of prudence and diversification, loyalty, following the plan documents, protecting, the integrity of the plan's assets and the investments and making sure that contributions come in and the plan is properly funded, to have appropriate liquidity for distributions, all the filings, and just to do everything to make sure that the plan is, in compliance with its obligations under the plan document and the general fiduciary standards. So I would say that during these times, fiduciaries be aware you're going to be under heightened scrutiny. When the going gets tough, people are going to be looking in the rearview mirror and second guessing a lot of your decisions. People are going to be monitoring you closely, following investment results, and so on. But the game, if you will, the standards are, are the same. So I think that's an important thing to remember. Some other general comments I would make, just about the fiduciaries in general, and some of them will follow through on the other slides. Remember that oftentimes we'll have situations where a fiduciary to a plan, is wearing two hats, and as a member of management or with a specific responsibility to the plan sponsor or the company, obviously that's your corporate or that's your business responsibility. When you're dealing in your capacity with regard to the plan, you're putting on a fiduciary hat, and now your direction and your focus appropriately changes. And, sometimes there can be a conflict between what you're doing with regard to the benefit of the company as a whole versus your responsibility when you're wearing your fiduciary hat. And we know from the Supreme Court in the Verity case, it's okay to wear two hats. You're a fiduciary to the extent you're engaged in that activity. But I think it's very important to be mindful of when your responsibilities go in one direction or the other, and how you address those potential conflicts in terms of your, in terms of plan governance. The other thing I would point out generally is that plan communications during this time are going to be especially important. When things get tough, you're going to get a lot of questions. People want to know, how are my benefits? How's the company doing? Will I get paid? Are we liquid? And I think you need to be very careful and responsible about the way you provide information, your duty to be truthful and accurate and timely in responding to questions, how to be mindful of separating responsibilities to the company when you might have, you know, inside information, so to speak, confidential corporate information versus your duty as a fiduciary to lay it all out there and do the best you can for the plan participants in the plan. And there's an art and lots of different, you know, guidance around those depending on the specific situation that you're involved in. So I would also point out, just generally speaking, remind officers and directors of the company that they are going to wear fiduciary hats oftentimes, and there's personal liability for fiduciary breaches or violations under ERISA, personal liability. So that's something to keep mindful of in terms of risk management and the risk management protocols that are, you know, that are in place. So lots of things to think about. These are all things that I'm sure you're aware of and you should be aware of in your day-to-day operations of the plan. Again, they just receive heightened scrutiny during these tough times, and we know from our experience there's a certain number of issues that tend to become highlighted or accentuated during these cycles, so we're going to try to grab them for you. So let's go first. We're on the slide here on plan administration, which goes back, I think it's number 27. It's really important during these times to make sure that the actual implementation of fiduciary responsibility, that there's a platform in place that really works. The way people communicate, the technology systems to support decision-making, documents, notices, filings, everything needs to work. And especially now with so many people, you know, working at home and what the future might look like, you know, 3, 6, 9 months, a year from now, as we continue to come out of, you know, continue to go through and hopefully out of the challenging times we're in, the way people work will be more reliant on technology than ever. So, you know, the committees and the boards need to be able to act efficiently and timely and accurately with regard to all the communications. Signature authority needs to be appropriately established, and electronic means of notarization and signing is available right now. Various states are enacting legislation about electronic notarization and enhancing e-signature protocols even more, so we need to be mindful of those kind of things as it relates to your discharge of your administrative duty. Remember, a lot of times when we talk about fiduciary matters, people tend to go right to investments or other things, but one of the prongs of the definition of a fiduciary under ERISA is, you know, the administration or management of the plan itself. So a lot of these decisions are going to be subject to the highest standards. One thing I want to point out is the effectiveness of electronic disclosure. Let me just take a minute. We had a client alert on this a couple of weeks ago, and I just want to point out to you that the Supreme Court had a decision recently in the Intel case, Intel Investment versus Suleiman, if I'm pronouncing that correctly. It involved a variety of issues, and one of the issues is technically what date does the statute of limitations start to run? In other words, is it a 3-year statute or a 6-year statute? When does the participant, quote, know, close quote, of the communication? And long story short is that the Supreme Court found that, you know, statute runs when you have actual knowledge, and actual knowledge means more than just evidence that a disclosure was made. In other words, the plaintiff really has to know and understand and have actually received the communication. Now, there's a lack of clarity around this, and we'll be getting some more guidance in the future. But I want to tell you, it's very important, especially now as we're relying so much on technology. To the extent that we're making disclosures to participants and disclosures to other parties who are going to be, where you have a responsibility to inform and disclose to someone, and there's an expectation that they have an actual understanding and actual knowledge of what what is being disclosed, you want to make sure that people really understand what they're getting. Just sending someone an email might not necessarily be the end of the day. So some of the suggestions that we want you to be thinking about right now might be to, especially with participants when you're on the plan administration side, post an opportunity on the website for people to come into Zoom or some other platform for a meeting. Make it a mandatory meeting where you're going to explain what this notice is about. Go out of your way to give good summaries in plain English that people can read and understand, with the caveat that this is just a summary. The full document is coming behind it, but you want people to understand. Offer some recorded little, 5-minute or 10-minute explanations of the disclosure. Track who has received. You can do this through technology. The software enables you to demonstrate not only that you sent an email with an attachment to someone, but that they received it, they opened it, they read it, if they actually opened the attachment or not. There are things that you can do with delivery and read receipts. And of course, the DOL has its own rules on safe harbor for electronic disclosures. So I think this is a really important thing going on right now in the administration, in the fiduciary world of plan administration, that you should be especially mindful of, because the Supreme Court gave us some guidance but didn't give us the full answers within the last month or so. So we need to be very careful and attentive to that issue for disclosure. Also, administrators, as always, I think John mentioned earlier, it goes without saying that your service providers really need to be monitored. You retain accountants, record keepers, investment advisors, attorneys, or a lot of people that you bring on board to service the plan, and just making that appointment in and of itself, you might be allocating responsibility from you as a fiduciary to another party, but the actual appointment itself is a fiduciary process. So you have a duty to not only select the right person, but to monitor them and make sure that their ongoing engagement is appropriate. So the things you're going to be looking for, with your service providers is to see how they're responding to the current situation in terms of timeliness, their ability to deal with these, stressful challenges we're going through right now, fees, continuity of management, their own ability, I should say, to have business continuity plans, with electronic support, and their own workforce working at home, things like that. So you need to keep a good eye on your vendors and your service providers, especially the ones to whom you're allocating fiduciary responsibility. Slide, please. So, of course, one of the big areas, the most common areas of discussion around around fiduciary matters is plan investments, and we're in such a critical time right now. In the defined benefit world, we're very focused on our investments, our asset allocation. You should be focused on asset allocation, immediate liquidity needs given the volatility in the market. So one of the things that you want to be doing, of course, is to monitor investment performance, listen to your advisors and your consultants, have your internal meetings, make sure you go through the process of paying appropriate attention to all of these matters, and to document everything very, very carefully, because a lot of times the standard under ERISA for satisfying your fiduciary responsibility is not necessarily it's not always outcome determinative. It's so much of it is process and procedure. Did you ask the right questions? Do you make the right effort? And documentation has become so important, as we're seeing in all the regulations coming out of the Department of Labor and the SEC on related areas. So documentation is really, really, really key. So the kind of things you want to be doing now, of course, you want to be monitoring all your investments. How often do you monitor investments? Do you have quarterly meetings? Maybe you should up that a little bit right now. Maybe you should have or at least have an emergency meeting to see if continuing on a quarterly basis is appropriate or not. Having these formal reviews of your investments with your advisor is really key. Really assess the nature of the investments themselves. Neither John nor I nor our firm are investment experts. We don't profess to offer you investment advice, but we can tell you the kind of questions to ask and of whom they should be asked. And you should be working with your investment advisor and challenging them to ensure that your defined benefit plan has the right allocation, has addressed liquidity, you're in sync with with the actuarial needs and assumptions of the plan, and that you understand a certain amount of what the efficient market theory means and how that relates to your pricing and daily valuations, what you can rely on. Do you have the right diversity? Do you have the right diversification of this, given the status we're in right now? You want to make sure that you have the right mix of, stable value, conservative investments, and so on. Employer stock funds are always an area that requires special scrutiny. I'll talk a little bit about that more in a moment. And just try to plan for the future. Try to anticipate, imagine out, alternative one, alternative two, alternative three. If things, what's the best case? What's the worst case? What are we expecting? What might it look like for the next 3 months, 6 months, 9 months? It still might be a little bit early in this economic cycle to make some decisions. People might want some more data and see how things go for another month or 2 or 3 or 6. It depends on your investment advisor and its methodology. But clearly, these are the kind of questions that you want to and need to be asking right now. You might want to consider, even though it's not a fiduciary function per se, how you communicate with your participants. What kind of education, to the extent you have investment education about your defined benefit plan, for your participants. They understand that you're funding a specific benefit with a formula, but they might have questions that come up, about funding and what you're doing. So you want to educate them so they can appreciate what you're going through in terms of the financial markets. You want to be asking your advisors about the fee structure and the fund structure of the investments that they're in. I think for those of you with cash balance plans, a variant of a defined benefit cash balance plans, the whole interest rate, you've been dealing with the drop in interest rates for a long time. That continues on now, so you really need to think about if there's any immediate impact now on interest crediting rates in light of what's happened over the last 60 to 90 days. And just again, the overall investment strategy and funding. Also, in terms of, John gave before several examples of planned freezes, and those I think the decision to freeze benefits at the employer level tends to be a set law or non-fiduciary function, but let's remember that the implementation of a planned freeze is going to be a fiduciary activity and something that you're going to have to pay attention to. So in addition to, the other, John mentioned proprietary funds before, to be sensitive to those. I think you want to be looking at your stable value funds. That's pretty common to have some sort of stable value fund as part of your maybe investment, in your pooled investment and in your defined benefit. You want to see if that's the right kind of fund to meet that asset allocation right now. Sometimes there's been a lot of pressure and opportunity with alternative investments over the last number of years. People are looking for alpha. They're looking for more return. They have funding challenges, pressure from the IRS, pressure from the PBGC. Get those returns. And people are oftentimes presented with non-traditional alternative investments. And they're not illegal. They can be appropriate. Your investment advisor, can and should work with you on those, and they will decide how appropriate those fund structures are. But I would just remind you that this is a very sensitive time, and that you need to give special scrutiny to any, sort of alternative investment, to the extent you have an allocation for hedge funds or private equity. You have to look at those, especially in the current environment, to think about the fees that you're paying, the risk reward of the investment. Are they appropriate? Do you stay in there? Just make sure that you've at least asked the question about how they fit into the current investment mix for your plan, given the situation we're in. Same thing with actively managed versus index funds. A lot of, your advisors will put a certain percentage of your funds into actively managed, a certain amount of your investment of your defined benefit into actively managed accounts. Those tend to carry a little higher fees because they're actively managed. They have a different management style. They're more hands-on, maybe a little more tactical. There are many arguments to be made for index funds. I'm not here to decide the pros or the ultimate winner of that. There are pros and cons to both, but these are the kind of questions that you want to be as a fiduciary that you should be asking right now about the investments in which your defined benefit plan are made. Plus, many of you are probably, very heavily in individual securities. Those are some of the other investment things that you want to look at. Documentation, as I said. So those are a few of the issues I just wanted to call out to you on plan investments generally. Let's move the slide forward if we can, and talk a little bit about employer securities. Now, this is an area that we see during prior downturns, back to the mid-'80s when we had a junk bond crisis, to, one or two recessionary cycles, 9/11. There are various times in the cycle when, the market gets extremely volatile, and the question around employer securities always becomes paramount. So I think you need to understand as a general proposition that anytime you're investing in employer stock or employer real property for that matter, you have to do it within, of course, you want to do it within the permissible range that ERISA allows you to do so, in terms of the statutory permission. What we typically see, with ESOPs, with employer stock, we see a lot of activity around common stock funds. This is where, your defined benefit plan might have a certain percentage which goes into its own stock, which, that can be a good thing. You're investing in the company and you believe in it and you believe it's a benefit for your employees. It also has its own tax and financial advantages. So right now, you can expect a lot of questions about company stock and whether you have it as a, direct share or unitized fund, however it's structured in your DB, you're going to get questions about it. Some industries will be very vulnerable, airlines, hospitality, restaurants, retail. And if you're a public company, you're always going to have questions about what did you know in terms of inside information? Is it protected, under the securities law? Did you tell us? Should you tell us? There are a lot of tough issues around company stock, and in a privately held situation, of course, with in an ESOP scenario, valuation is always a challenge, and you have diversification rules, and employees have the option to put stock back to the company. Do you have the liquidity? So those are the kind of things you generally have to manage around employer stock during these times. I want to say that the public company stock, we've had some court cases recently involving, involving public stock that have had a lot of attention. The Supreme Court just issued a decision a couple of months ago back in IBM, and the question there, they remanded the decision back to the circuits. But for a while there had been a kind of a presumption of prudence under the Dudenhofer case, and then we got into some issues procedurally. In Dudenhofer, that case said that a plaintiff, states a claim. A plaintiff would adequately state a claim that plan fiduciaries breached their duty on inside information, where they have these, inside stuff that might be protected by the securities laws. If the plaintiff, could allege an alternate action that was, either consistent with the applicable securities laws, or that a prudent fiduciary in the same circumstance would not have viewed it as more likely to harm the employer stock fund than to help it. So there's been a lot of discussion around inside information. What do you know? What's your duty to the company versus the plan? In a securities law context, there's a lot of tension. And basically, the Supreme Court just remanded back to the circuits some of the issues that we have been hoping that they would decide. So we had thought that coming out of Dudenhofer, they'd be talking about, how the duty of prudence doesn't necessarily require that a plan fiduciary has to violate the security laws. To what extent, you have to consider the conflict between ERISA and the securities laws, regarding whether, based on this inside information, you have a stock trade or make a disclosure, and so on and so forth. And the Supreme Court kicked it back down to the, they kind of ignored, there were briefs filed by the Department of Labor, the Department of Justice, and the SEC, and the Supreme Court said that the plan fiduciaries hadn't really addressed the primary issues that I just mentioned before that came out of Dudenhofer. Instead, that they were arguing that they're making the argument now that fiduciaries have no duty to act on inside information under ERISA, period. In other words, if you're in the management team and you have some inside information, notwithstanding your ERISA responsibilities, if you're in a dual role, you don't have to do anything about it. And the federal agencies were arguing that this duty under ERISA to disclose would conflict with securities law, and that the only duty to disclose we make it for because of these tensions and conflicts for an independent fiduciary to be retained to address the employer security issue on behalf of the plan participants. And that's something that, as a firm, we've been engaged in that before, and that's something that, is available, at the right time, under the right circumstances. That's something you might really want to consider as to, which is whether or not an independent fiduciary might need to get involved with untangling your complex employer security issues. Next slide, please. Thanks. And as a final point, I would say we're talking about fiduciaries. Who are the fiduciaries? I mean, every plan document has a named fiduciary or a process, that tells you how to identify fiduciaries. But you all know from experience, the plan sponsor, is typically a fiduciary unless another party is named. You have a trustee. You can have an administrative committee that's named. You can have an investment committee that's named. Anyone that's engaged in providing, advisory services or investment management is likely to be a fiduciary. You could have third-party 316 administrators that, actually exercise fiduciary responsibility. So one of the things that we've learned from the past is that sometimes people really aren't sure how their fiduciary governance is established and who the fiduciaries are. So I think it's really important right now. You should be doing this anyway, as a matter of course, but especially right now when you can anticipate, some questions from participants or from regulators or from the marketplace generally. Who are fiduciaries? How has that responsibility been allocated? How are we monitoring the appointment and supervision of these fiduciaries? And again, remember, fiduciaries are going to fall into investment advisor category, people providing advice for a fee. Investment management, where people are managing assets of the plan with discretion. And I'll just call it administration, but where people have, the authority to manage and make administrative decisions on behalf of the plan, like whether or not someone's entitled to a benefit or how a vesting provision applies, things like that. So it's really important, I think, to allocate from a risk mitigation point of view, who are your fiduciaries? Are the responsibilities properly allocated at the moment? Are we properly supervising all those people? Do we have any inadvertent fiduciaries out there? Because regardless of nomenclature, you're a fiduciary to the extent you actually exercise or engage in that activity. So you can't label someone a fiduciary. You can label someone a fiduciary, but if they don't do anything or engage in fiduciary activity, they won't be one. Conversely, one might not be named as a fiduciary, but to the extent they actually exercise that function, they will be deemed to be one for purposes of the law. And the related issues there are to look at your bonding, and bonding is a requirement, of course, your ERISA bonds for handling of plan assets under ERISA, and your fiduciary insurance. Now that ties into your E&O. Fiduciary insurance is usually a separate rider or a separate policy. Most E&O policies exclude ERISA fiduciary activity unless there's a rider or a separate policy issue. So you want to make sure that you're properly covered. And with that, John, do you have any final comments to make before we wrap up?
I do not have final thoughts. We definitely expect there'll be a lot of questions that come up because of this presentation or in addition to it. And our email information is in the packet on the website. Anybody should feel free to contact us if they need more information.
Yeah, and this recording of this webinar and the slides and other materials, which I want to compliment you, John, because you prepared the slides and some of the outline materials, all the outline materials that go with it. So it was fantastic stuff. Thank you very much for doing that. It was really great material. So that stuff will be available, on the web, or you can call John or I, and we will get it to you. If you have any questions, feel free to call us or any of your other contacts at the Wagner Law Group, and we'd be glad to answer. So with that, we hope everyone stays healthy and safe, and wishing everyone the best. Thank you so much for participating and joining us today.